All right, everybody. Let's go ahead and get started. My name is Chris Kawasaki. I'm a local real estate agent here in Southern California, so I'll be hosting the seminar. And we've got some great guests here today. But yeah, I just want to talk a little bit about trusts, estate planning, things like that. Hey, good morning. So, you know, the reason why I wanted to do this is first, I'm learning about it as well, because I need to get a trust for our family. But, you know, I've seen it all the time where in real estate, when someone's trying to sell a house, someone passes away and they don't have a trust, it can cause a lot of problems. And I've sold houses where they have a trust and it's just like a regular standard sale. You know, you put it on the market, get an offer, goes through the process. But if they don't have a trust, and I'm sure Marin will talk about this a little bit more, is it can cause all kinds of problems. And I've seen it to where it could take 6 months, a year, possibly more, to where they can't even sell the heirs can't even sell the house after the person passes away. And if that house has a mortgage on it, that causes problems for the heirs because they aren't expecting to pay an extra mortgage. So it's a big financial burden on the family members a lot of times. So Marin will talk about that a lot more. But in the meantime, I wanted to bring Frank Delgadillo up. He's one of my lenders that I use. And I wanted to let him give a little bit information to you guys as well. Okay, go ahead, Frank.
Okay. Hi guys. Good morning. Good morning. Let me just find out where we should kind of set up. So we're doing things here in live. Oh, perfect. I was meant to be here for you. Well, thank you guys. Thank you, Chris. Thank you guys for all for being here on a Saturday morning. So I'm a mortgage lender. So that when it comes down to a home, most of you already own a home, right? Who here is a homeowner? All right, good. So perfect. So this class is for you guys. As it's important when it comes down to getting estate planning, getting your wills, your trust done, because for whatever cost it is, and it's a low cost when you think about it, if your house is worth more than $10,000 than when you originally bought it, it's worth getting a trust. And that's pretty much it. So when people are like, it's expensive or whatnot, trust me, no pun intended, but trust the trust that it's here to help you guys out. With the mortgage part, it's also important that your mortgage is also put in the trust so that way they know who they're going to be paying if something should ever happen. With that in mind, I'm a mortgage lender. I'm in Glendora. I've been doing this for 25, 26 years. So I want to say that I'm pretty well knowledgeable in the mortgage financing. So whether if you're thinking of buying another home with the current one you have, you can do that. And if you're thinking of passing on your home to your children, it's also important to know what's the process with all that. And I'm here to help out with any of that. Thank you.
Okay. Yeah, so great points. So our main presenter today, what you guys are all here for, is our estate planning attorney, Marin Bradshaw. So we'll bring her up and have her talk. Thank you, Marin.
I'm really delighted to be here. Oh, thank you. And thank you, Chris, and thank you, Frank, for inviting me. One of my favorite things to do is talk about just the foundations of estate planning, because I think it's something that a lot of people don't realize they have a need for, but they do once they know what's involved and what's behind it. So a little bit about myself. I grew up in Southern California. I went to high school, college, and law school in Utah. After law school, I actually went into criminal law. I wanted to be a criminal defense attorney, and I did that for a few years. What got me into the estate planning side was when I started having kids, and one of my children was diagnosed with autism. So I was now in this community of families who had a child with special needs. And all of a sudden I'm thinking, if something happens to me, what's going to happen to my son? Like, he may not be able to support himself. He's not going to have the same opportunities that I did. And what can I set up or organize to take care of his needs? So it's not the reason a lot of people start thinking about estate planning, but that was what got me started in this area of the law. I've been doing it now in Southern California for 15 years. Before my prior life was in criminal defense. I'm what's called a certified specialist. So I took a separate bar exam just for this area, and this is all I do, all day, every day, is set up plans for families, administer those plans for families after the death of a family member. And then I also, a big part of my practice is dealing with disputes on estate plans. So people fighting over mom and dad's property, people fighting over big things, little things, all kinds of areas for dispute. So one of the things we're going to talk about a little bit today is where those problems come from and what you can do to potentially avoid that, because not all issues in estate planning are financial. In fact, one of the reasons I love this area is because we're not just talking about money, we're talking about people's values, we're talking about what's most important to their family. And that's what gets me up in the morning, is working with people and talking about what's most important to them. So a lot to break off, but we'll do our best to get started. So here's the agenda today. We're going to start by talking about what's an estate plan. What do I mean when I talk about an estate plan? Is that just a will? Is that something more? Is that only for rich people? Is that like, what are we talking about with an estate plan? And then we're also going to get into what an attorney who does estate planning actually does and what they bring to that conversation. We're going to talk about powers of attorney, what that means, and how that interplays into the estate planning conversation. We're going to talk about wills and trusts. What's the difference between a will and a trust? You hear people say you really need a trust. Okay, but how is that different from a will? What's written down in the trust that's not in the will? We'll talk about that. Special situations, this is things like irrevocable trusts. What do those do? Some of those special situations, like if you have special needs people in your family, how that might come into play. Blended families, when you've got children from separate parents involved and you want to provide for them, what do we do with those? I'll touch on some of those situations and we can get into that a little bit. And then again, how to avoid trust and estate litigation and what I've seen and where that really comes from. So we'll see how we do on time. So let's start with, I don't have an estate. I hear this a lot. I hear this from people who have net worths of over $10 million, and they think they don't need an estate plan because they don't have an estate. They're picturing like a mansion or a castle in England, yacht on the Riviera, because that's what they think of when they think of an estate. But all an estate is all the property you own, and that's it. That property could be your clothes and furniture. That property could be your retirement account. That property could be your annuity you get from your work or your pension. And then for other people, that could be your residence. Maybe you have a rental. Maybe you have a timeshare in Mammoth. I don't know. But it's different for everyone, but everyone who owns something has an estate, right? And then the estate plan does a lot of things. It doesn't just say who gets what on your death, which is what most people think about, right? You think your estate plan is, I'm going to give my watch to this person, I'm going to give my piano to this person, I'm going to give my bank accounts to this person, and that's my estate plan. And that is part of what the estate plan does, and it's certainly what most people think about, but a complete estate plan, a full estate plan, says, first of all, who's going to act on your behalf if you can't act for yourself? Most adults, more than 50%, the majority of adults are going to be incapacitated at least for some period of time before they die. If any of you have taken like a parent through incapacity or have had a parent pass on, maybe you've seen that, right? There's some period of time where they can't write their own checks. Maybe they have dementia. You might have some period of time where they're physically incapable of handling things, where they're not able to communicate with doctors and make their own decisions. This isn't like a once in a while thing. Most adults will have some period where that's the case. Your estate plan takes care of this period. Also, you plan for healthcare decisions when you can't make your own. That's part of a complete estate plan. You talk about guardians if you have minor children. That's in your estate plan. You identify beneficiaries. This is, again, what most people think, right? You're talking about who gets what after you die. That's in your estate plan too. And then you give directions, and this is important, to the person who's going to carry out that plan, right? I have a daughter who's 14 years old. I want her to have part of my estate when I die, but I don't want her to just get a check, right, for half the value of my house and whatever else I own. She's 14 years old. So my estate plan needs to name a guardian for her, and it needs to say at what point she's actually going to get that property. And it's going to say, in the meantime, who's allowed to decide where she goes to school, and who's allowed to decide at what point things get paid for, right? How much is going to apply to her college? What does she need to do for herself? All of this is part of a complete estate plan. And then finally, it deals with taxes. Estate planning attorneys are educated in the tax element of things. There's a personal side to this, but there are a lot of layers of taxes that come into play. Okay, so this is the basics. All right, this is another piece I hear a lot. Doing an estate plan is only for old people. I don't need an estate plan because I'm not an old person, right? I get it. It doesn't feel like, it's not pleasant to think about what happens when you're going to be in a coma or after your death. And for all of us, that's going to be a long way off, right? We hope. But you never know. You don't know what you don't know, right? And I can tell you from my experience that even when I've done planning for 22-year-olds, they leave that meeting after they've signed everything and they know that they're set up. They leave that meeting with just so much peace of mind. They get on that elevator down from my office knowing that whatever happens, they've got their plan written down on paper. So worst comes to worst, they have some control once things are out of their control. So keep that in mind, but just to kind of go through this puts the control back in your hands. There is an estate plan written for you by the state of California. It's in the California probate code, and it will say all those things we talked about. It says who's going to take care of you if you're incapacitated. It says who gets your property on your death. It says at what age people will inherit. All of this is written down for you. You just haven't read it yet. And for some people, it's not too far off from what they maybe want, right? Like, for example, the person who has first priority to handle your affairs if you become incapacitated would be your spouse if you're married. That's what a lot of spouses would want anyway, right? That's not what everyone wants. I've done estate plans for people where they're in the middle of a divorce and the last person they want deciding what happens to them is their spouse, right? Or the last person they want making those decisions is their child. I just said I have a special needs child. I don't want him to be in charge of those things. I love him, he's great, but that would be way too much responsibility for him. It would be completely inappropriate. So I want an estate plan because I want to know what that plan is, and I want to be in control of those decisions. Okay, the next reason to do estate planning now is that you'll have the state law in charge of what happens, but also it will all go through what's called probate court. Probate court is not a scary place, but it is a court. I'm in court all the time, and it's very time consuming. If anyone here has gone to court before, it's expensive, it's confusing, and it's time consuming. Like Chris said when we started, a court-supervised probate process, and this is if somebody dies without a living trust or they need some kind of intervention from the court, it takes at least a year before it's closing because you need a certain number of months before you get that first hearing. Once you get the hearing, all it does is open the probate. You've got a couple of more months before you get all your paperwork back so you can start the process. You have a mandatory 4-month waiting period where creditors can make any claims on the estate. Then you can get going on the next steps to just organize things all with the court supervision. If you want to do anything, you ask the court for permission. That's another hearing. Every step of the way is overseen by a judge. It's really organized. There's a lot of pieces to it, but it's expensive. And you'll be in the time when your family is going through a major family transition, they're also having to deal with the time and expense and complications of being in probate court. I have seen very few families where this is the ideal situation for them. Sometimes you end up in court anyway, right? But why have that time and expense and complication if you don't have to? So what I tell people is the time to plan is now. Even if you have some major transition coming up, just put a plan in place now. You can change it later, okay? And then once you have a plan, maybe you have one that's old, right? Once you have a plan, the time to review it, 1 to 5 years, it depends on your age, it depends on what happens. But I tell my families, look, when it's tax time and you're already going through your taxes and your finances, pull out your estate plan and make sure everything that's in there is still true and is still the way you like it. Maybe you had another kid and you forgot to update your estate plan and you want to make sure everyone's named. But the biggest pieces that affect estate planning are marriage, divorce, death of a spouse, birth of a child, death of a child, or other beneficiary. These are the things that change the main functions of an estate plan. That's when you want to get it out and review it and maybe update it, okay? All right, so what do I do? I'm an estate planner. What do I actually do for my clients? Because in these days, you could go on ChatGPT and say, ChatGPT, I need an estate plan. Write me an estate plan. I'm married, I have 3 kids, I live in Southern California, I own my house. Like, you could put in all this information, right? And it would give you documents. I mean, and that absolutely happens. So why would you work with a lawyer to do this work when what you're getting after paying a lot of money is paper, right? And you can have that written up by a lot of different programs and stuff right now. So the first thing I do as an attorney is I listen and I ask questions. It sounds so simple, but let me tell you, I always have to remind myself that that's the most important part of my job, is to be curious, listen to what people have to say, and ask questions. I have heard more things as people are standing up and walking out that change everything for their estate plan. For example, I'll sit down with a husband and a wife, write this whole long plan, and then halfway through that meeting, I find out they're not actually married, but they consider themselves spouse, they're life partners, they've been together for a lot of years, but they're not legally married. Well, that changes everything on the plan, because there's all kinds of tax issues, there's all kinds of inheritance issues that are completely different if you're not married, right? And same with kids. You might have people you've raised as your children, but if they're not your children, then we need to be careful with that planning. So the first thing I do is listen. The next is that I look at whatever they have now. Not only their existing estate planning documents, but maybe there's a prenup, maybe there's some kind of an agreement they have. They're in a partnership for a business with their brother, and they wrote out the partnership agreement. I need to know what's in there. I look at everything having to do with their property. Then we talk about all these issues that might change their decision making. Because there's pieces about estate planning that you don't know what questions to ask unless somebody's really, really working with you, advising you about it, right? So people will have a blended family, and there's all kinds of different shapes and sizes of families now, right? People who are married and then remarried. They have children from several different partners. They're raising their grandchildren. There's all kinds of families, and that will all affect what you might have in mind for inheritance. We talk about family members with special needs. We talk about various types of taxes. Most of the conversations I have with Californians are about property taxes, not estate taxes, not gift taxes, not income taxes. We talk about property taxes because most people's wealth is tied up in their very expensive California real property. And if they have a change in ownership, that property tax will be reassessed. We need to talk about what impact is that going to have. If something happens to you and that gets inherited by your children, are they going to pay the same property tax you paid when you bought the house in the 1980s? Or are they going to pay 10 times higher, right? Add a zero to that property tax bill and see if they're able to still afford that house, right? So we talk about that a lot. And then we select fiduciaries. What do I mean when I say fiduciaries? This is the person who's going to act for someone else's benefit. So that could be the guardian for your children. That could be the person who handles your trust, called a trustee. That could be the person who handles your will if it has to go to probate court. That's called your executor. We talk about who slots into those different spots. And sometimes people walk into the meeting saying, I know who I want. It's going to be my oldest daughter. My oldest daughter, I've always planned on her taking care of these decisions. She's in charge of the whole family. This is who I want. And then when we talk a little bit more about what's involved in that job, maybe the oldest daughter is not really the right person for it, right? Maybe the oldest daughter is in like a decades-long fight with her younger sister. And having to take care of younger sister's property is not a good idea for oldest daughter. Maybe oldest daughter's gone through bankruptcy and she can't carry the home and the mortgage, and like she can't qualify to take care of these properties and to step into some of the financial obligations that you have in your estate. So we need to really get into detail. And let me tell you, if you know anyone who wants to be a lawyer and they are thinking maybe about estate planning, it's the perfect job for a really nosy person. Because I ask people about fighting with their spouse. I ask them about all their money. How much are you making? What do you owe? Does anyone owe you money? Are you getting along with your kids? I was surprised by how many people tell me they have secret families in other countries. I learn everything about everybody. So, because this is what it means to work with an attorney, right? You get something that's tailored to you, right? It's not something you could print off at the stationery store or something you could pull out of ChatGPT. It's something tailored to you. So this is what it means to work with an attorney. Quick little story. My older brother, super, super, super smart. Maybe the smartest person I know. Went to Harvard, got a PhD. He works for a bank. He makes millions of dollars. He does really, really well, okay? He was kind of in a hurry to get his estate planning done, and he lived outside of California, so I couldn't help him. So he printed off a document to just create a will. So he has a bunch of kids. First marriage, a lot of kids, but it's a joint family. Like, it's a pretty traditional family. So you would think this super smart person who's not afraid of reading papers would have no problem with that. Well, he created the will, wrote it up, and it did all the things he wanted it to do. But then when they signed the will, he had his wife witness the will. You can't do that. The will's not valid. In fact, the real law, after I looked it up in the state where he lived, the law says it is valid, but the person who signs the will can't inherit anything if they're related to you. So by doing his own estate planning, he accidentally disinherited his wife from his plan, right? So it put him in a worse place than he would have been had he done nothing at all. Because if he'd just died, his wife would have gotten everything, which is what he wanted, right? So this is this is why you want to work with a professional to get these documents done. Okay, so work with a professional just like you would with anything else. Here's when people bring in their old binder of documents, might be an old estate plan, might be other legal paperwork, this is what I'm looking for. I want to make sure that if they have a trust already, that everything is owned by the trust. So when we'll talk about the difference between a will and a trust, but this is one of the things I'm looking for. Who actually owns all your assets? And are they tucked and tied into what you plan to have happen, right? If you have a husband and wife and a child, right? And husband opened a joint account with child. When husband dies, child just owns that account, okay? They just own it as a joint owner. That's it. That's an estate plan by itself, right? After husband dies, money goes to the child. The child just owns it as the remaining joint account holder. Is that what they wanted to have happen? If it was, then that works. But maybe that wasn't what they wanted to have happen, right? Maybe that was supposed to help pay for a funeral. Maybe that was supposed to be savings for something else. Maybe that was mom and dad's walking around money that they're using to buy groceries and pay their mortgage. There's these groups that are sometimes referred to as trust mills. That's not how they refer to themselves, but these are companies that create and sell estate plans that are kind of, they're all identical to each other. You put your name on the front, and you've got an estate plan. The topics that they typically neglect are they're usually not specific to the state where you live. California, we love it. We're all here for a reason. Has very specific laws. There's inheritance laws in California that you won't see in any other state. There's rules in California you won't see in any other state. So a lot of times these documents that you can just purchase, they're not specific to California. They won't hold up in California the way that they read in the document. Also, these documents are typically not for families with special circumstances. They're going to be for families that are what I kind of call the Ozzie and Harriet families, where it's husband and wife and 2 kids, first marriage. They own their property together. They want spouses to inherit and then it divided equally and outright to the kids. This is what a lot of families want to have happen. But if you have any possible difference from that basic plan, then a lot of times these trust mills that come up, they won't take care of those needs. Again, it might say it will, but it won't do what you expect it to. Also, if you have documents that were created 30 plus years ago, even 10 plus years ago, the inheritance tax rules have changed significantly since then. We hear in the news about the big beautiful bill, or we hear about all these different tax plans, and a lot of attention goes to the income tax ramifications there, because that's the biggest impact. But a lot of them, all of them, every major tax plan that comes from the federal government includes something about estate tax and gift tax and things that have changed. So in my 15 years that I've been solely in estate planning, I've seen 4 major pieces of legislation that have turned the estate tax issues around, and they haven't always made the news. So when you got a plan that was written at a time we were under a totally different landscape tax-wise, you want to get that looked at to make sure you're not walking into a tax trap, right? You might have a plan that assumed transferring property between parents and children wouldn't result in property tax reassessment. That's not true anymore as of 5 years ago, okay? So this is another reason to get your plans looked at, because there's been some major changes. Then we kind of already talked about the family changes that might have triggered a need for an update. So let's talk for just a short time about planning for incapacity. This is while you're still living, but you're not able to take care of your own needs. You have powers of attorney. This name's a little misleading, but it's been around for centuries, where a power of attorney is a document. It's not a person, it's a document. And it's a document that names an agent who can act on your behalf. In this case, it's called the principal. You have the principal who gives the power to the agent who can act for the principal, okay? The agent on a financial power of attorney document, it says my agent can do X, Y, and Z, and if they take this action, it's like I took this action, okay? So if you give someone, or sometimes they're called an attorney in fact. I call them an agent because if you call them an attorney, it kind of makes it sound like you can only use an attorney for this job. It's not true. You can name your spouse, you can name your child, you can name your CPA, you can name your attorney, you can name anyone to act as your agent. But in your document, you say when those powers are conferred, and you say exactly what those powers do. So my power of attorney, my personal power of attorney, names my husband as my agent. His powers are effective now. He could call our credit card company, call my credit card company, and if they're like, I mean, have you ever been on the phone with your insurance or your credit card and they say, oh, I can only talk to the spouse, or I can only talk to the card holder, right? If you have a power of attorney, you can say, I have a power of attorney, I can talk to you, I can act on their behalf, right? And, but you have to have the document, because the document is what says what exactly they can do and when they can do it. Because you don't want to just give someone full power to do anything, anytime, and pretend to be you. You want to kind of control this. A lot of people's power of attorney are effective only after a doctor says they're incapacitated. Some people's powers of attorney say only if 2 doctors say they're incapacitated. And so that's a financial power of attorney. That's only for things having to do with money, but it's a very powerful document because the person can stand in your shoes and make financial decisions on your behalf, right? You also have an advanced healthcare directive. This is a document that names an agent to make personal decisions about your care of your physical human body, okay? They can't make financial decisions. They can't call your credit card company. They can't file a lawsuit on your behalf, but they can make decisions. They can give directions to your doctor. They can take you off your breathing tube. They can decide what medications or treatments you'll have. They can decide if you're going to be cared for in your home or if you're going to be moved into an assisted living facility or a skilled nursing facility. This is the person who decides how you're going to be cared for, all right? And then in this document, same thing. We don't want to necessarily say anything my agent says is what is going to happen. You say when they get that power and what exactly they can do. So in the California form for a power of attorney, for a healthcare directive, it'll have a specific section where you say, okay, for end of life decisions, how much can your agent decide? And what are your wishes? Does anyone here remember the Terry Schiavo case from like the 90s? This woman, she was incapacitated in Florida for years and years and years. She was young when this happened. I was younger than she was, but not much, when it happened. But I looked it up. I mean, she was young. She didn't have an estate plan, and she was being kept alive artificially for years and years. Her husband wanted to move on and was advocating to take her off the artificial life support. Her parents didn't want to do it, so it was this huge legal battle, right? And no one knew what she actually would have wanted in that situation. The healthcare directive lets you say what you would want to have happen. It can be pages and pages and pages long. I have people who tell me all the details of what they want to have happen for their care if they're ever in a position like that, okay? And then I have other people who say, well, here's generally what I want, but my agent, who I trust, can make the final decision. At least one person's in charge instead of your spouse and your adult children and your parents all weighing in and telling the hospital what to do. Then the hospital also deciding what's most likely so that they don't get sued, right? This names an agent who can make those decisions. And then also your healthcare directive gives you a place to put down what are your wishes for your body after your death, right? I have people who are really, they have very specific, religiously driven tenets for how their remains are going to be handled after their death. Healthcare directive will put the agent in charge and say, I cannot be cremated, I should be buried. I want to be buried near my parents. Or I definitely don't want to be buried. I want to have my ashes scattered over the ocean at sunset on some day. Like, you can get very specific because, again, this is highly, highly personal. And I'm surprised all the time by what people are thinking and what's most important to them in these documents. Having it written down, speaking as someone who's been on the administration side for my own family and for other families, it gives them so much peace of mind to have direction from this person that they love when they can't communicate with them directly. This is a gift to give your family at a time when they really, really will be looking for direction, and you can't give it directly. So make those decisions now and take that pressure off of the people who are most important to you. All right, so there's some misconceptions about powers of attorney. One is that the power of attorney is kind of all-inclusive and it means you can do anything. That's not true. A power of attorney is limited to just what's written down in the document. So if you have one prepared, read it carefully. One example, I always make sure my power of attorney doesn't let the person who's on the power of attorney change their will or their trust. That is where I draw the line. You can give them really broad power, but I don't want the agent, when you're incapacitated, to be able to write down a new estate plan for you, where who gets what after your death. Too much messy conflicts of interest there, right? But that's one. Another is that the power of attorney still works after someone dies. It does not. If you have a power of attorney for someone in your family or someone close to you, after their death, you must stop using it. It is void. If you do use it, you're committing financial fraud because the power of attorney assumes this person is still alive and they're still okay with you using that document. So I've seen lots of people in good faith accidentally use the power of attorney to keep moving things around. They're paying for the funeral, they're covering bills, but they have no authority. So these are two places power of attorney goes wrong. A lot of people have asked me lately about conservatorships. I think this comes after Britney Spears, and so people know about conservatorships more than they used to. A conservatorship is a little bit like a power of attorney, but this is a court-supervised situation. This is, again, when someone didn't write down documents, or situation has changed and the documents won't work, okay? So I don't know if Britney Spears wrote an estate plan or not. But if someone has a power of attorney and then they revoke it, or the power of attorney doesn't give enough powers for what this person's needs are, then the only way that someone can act on their behalf for financial affairs is by going to court, filing for a hearing, getting a lawyer. The lawyer for the person who's potentially incapacitated also needs to be either appointed by the court or someone else, give notice to the whole family, and then the court supervises this financial situation where someone else is making decisions for an incapacitated person. Much more expensive, much more complicated, much more time consuming. A contested conservatorship, like the Britney Spears matter, those attorney fees were in the millions. They were in the tens of millions. Everyone had something to say. There was a lot of money at stake there and a lot of reputations. It was making the careers of attorneys, my colleagues in Southern California. So a court-supervised conservatorship is when you don't have sufficient estate planning in place to handle all the needs of an incapacitated person, okay? Sometimes it's still necessary, but that's the situation we're trying to avoid by doing planning. The most common situations that I've seen where there's fighting and litigation and lawsuits, when you've got what I call a dependent adult, or this is an incapacitated person, is when you have adult children trying to exert influence or control over an incapacitated parent. This is very, very common. And it's, the emotions are complex, the relationships are complex, the doctor's situation is complex. There's a lot going on here. It's a very, very difficult situation. And that's where I see the most litigation, is where you've got adult children. One of them wants to move mom to Arizona to live with her. Other children are saying, well, if she does live with you, then should you get rent? Should you keep getting her Social Security? Should we be paying you? There's money involved, there's relationships involved. And again, this is at a very sensitive time for the family, when they're maybe dealing with a parent who can't take care of themselves anymore. It wraps in all kinds of emotions, and it can become extremely litigious. All the more reason to have planning. Okay, so let's talk about, for lack of a better word, let's talk about death planning. This is after the person is not living but incapacitated, but after their death, okay? I took this scene from my favorite estate planning movie, Knives Out. But this is what a lot of people picture when they're thinking estate planning, right? The lawyer reading the will to the family that's all gathered around. So the documents that handle death planning are wills and trusts. Wills and trusts. Sometimes people ask me, are you a wills and trust attorney? Yes, I'm a wills and trust attorney. I do other things too, but wills and trusts are the most famous and the documents that a lot of people think of. So here's what's the same about a will and a trust. They'll both have provisions for who gets property after someone dies. But there's an important difference too. And because the difference is, and I'm going to explain it to you, it's not on my slide. The difference is your will is like an instruction letter to the court, and it can only be read and implemented by a court. It can't be handled privately with your family, okay? So if all you have is a will, you will go to probate court. The probate court will follow your instructions, okay? You're not going to use the state of California's rules for inheritance, so you can have a very complicated set of things in your will, but only a court can implement a will. Is that clear? A trust is intended to be administered privately outside of court. So we don't have all those waiting periods involved in the court. You don't have hearings. You don't have, you handle it privately, and you write in the trust exactly how you want things to happen. So in a trust, you can say, my daughter who's 14 won't get all the money that she inherits until she's at least 25 or 35 or 55, right? You can say in the trust, I want my son with special needs to have his share set aside in a trust that's outside of his control and access, so he can remain eligible for the government-sponsored benefits that he receives because of his disability. I can put that in my trust. It's very hard to implement into a will because it all has to be court supervised for years and years and years of how long that's going on, right? That's the biggest difference between wills and trusts. One is administered by a probate court, the other is administered privately. I still write a will every time I write a trust. The trust is far preferred, but I still write a will every time. But you know what a will says? It basically does one thing. It says, anything I own, put it in my trust. My trust is what should control everything, okay? It's called a pour-over will, because all it does is it says, court, if I end up in probate court, just give everything to the trust. My trustee knows what to do, and that's where all the big instructions are. I don't want the court to supervise what happens. I want my trustee, who I've named in my trust, to take care of everything. Make sense? That's the difference. Now, if you have, there's also, you can do planning with what I call built-in beneficiaries. This is kind of a quick and dirty solution to estate planning. You can put a pay-on-death beneficiary in your bank account. That'll go to that person after your death. But the problem with that, it's not, it will probably work. unless it doesn't, because the person you named died before you, or the person you named is going through a divorce and they actually don't want to get anything after your death right now, right? Or the person that you named has moved out of the country. They're not a US citizen anymore, and there's going to be major tax problems. So these built-in beneficiaries, that works, and I actually do recommend it for certain assets like retirement accounts and other assets, but that can't be the basis of your whole estate plan. It doesn't account for all the crazy things that can happen in a person's life, right? I would have never imagined that I would have a special needs child until I had a special needs child. I wouldn't have imagined that my husband's parents would die before he was 35 years old, but that happened. Like, you don't have some of these things that happen in life, you can't account for. So you can't assume that just having a pay on death beneficiary is going to cover anything that might change. A well-written trust will account for all those different contingencies. Okay, so we kind of went through what a will does, what a trust does. Another thing I wanted to just point out, though, is that the trust is a contract. It's a document, and it's a contract, just like your mortgage contract, just like your home purchase contract, and it has parties to the contract. There's 3 parties on a trust. You have the person who sets it up, you have the person who does the work, the trustee, and you have the person who's benefiting, the beneficiary, okay? So for example, let's say I write a trust, and I say, all of my property, I want my sister to be in control of. She's gonna carry out all my wishes if I can't do it myself. Then my sister, she actually becomes the one in control of all my trust property. My house, my bank accounts, my investment, my car, everything that I own is now in the control of my sister. But it's for the benefit of my kids, okay? And I write that all in the trust document. And it says, when she becomes the trustee, that's only if I become incapacitated or after my death. It says what she's allowed to do. She's allowed to buy property, sell property, mortgage property. She's allowed to distribute the property to my kids, but only if they're after a certain age. She's allowed to invest it, but only if she invests like a reasonable, prudent person. She can't keep the property for herself. She can't put it all in some really, really speculative investment. It's very specific on what she can do with the property. And again, that's a contract between myself, my sister, and my kids. The court doesn't read it unless someone sues about it, like any other contract. So if my sister doesn't do what she's supposed to, my kids are going to hold her responsible for not coming through on her end of the contract. Make sense? If a court was supervising that, they would make sure that my sister was doing her job. But I don't want the court involved unless it absolutely has to be. And I think my sister will take good care of my kids. So I can name her as my trustee. By the way, my sister's not my trustee. I was just using an example. but this is how a lot of people set up their trust. They want family, close friends, people they trust to take care of their assets, okay? There's not a lot of time to talk about irrevocable trust, but a lot of people ask me, a living trust, what's that? All that means is the trust is revocable. It means you can make changes to it. You can amend it anytime, you can get rid of it completely. Basically, you're in charge of that trust, okay? And that's why a living trust is so powerful. While you own the property and you're living and you have capacity, you can do everything within the trust that you could do when it belonged to you directly. It doesn't tie your hands at all. You don't pay separate tax return for that trust. You don't have to qualify for a separate loan on the property if the property's in a revocable trust. It's all under your credit. It's all under your social security number if it's a revocable trust that you're in charge of, okay? This is why it's the primary estate planning tool, because it gives you maximum flexibility while you're alive, but it still gives you all the control after your death. So that's the primary estate planning tool for revocable trusts, living trusts. This is what you're looking for as a foundational estate planning document. Irrevocable trusts, I would never write or recommend unless the client has the foundational revocable trust first, because that's what pretty much everyone needs. Irrevocable trusts are very specialized, they're very sophisticated, and they're really specific for specific purposes. This is maybe for someone who's in an industry with a lot of litigation and they want to have assets set aside in a separate entity for asset protection, right? It's not their primary estate planning tool, but maybe we set aside some assets that we want to put some protections around. We want to do some gifting that's not going to be subject to estate tax. So the property is maybe not in my control anymore, put it in a trust for my kids. I can't touch it anymore, it has to go to my kids, my trustee's already in charge of it. Out of my estate, I won't be taxed on it, right? Irrevocable trust. Foundations, you're looking at revocable trust, okay? There is asset protection. Most asset protection for yourself would be in an irrevocable trust. But the only reason that it's protected from your creditors or other people who might sue you is because it doesn't belong to you anymore. It belongs to the irrevocable trust that you can't change. So some people come to me and say, write me a trust because I don't want anyone to be able to sue me. You can always get sued if you own anything, and I think you still want to own something, and for that you'd want a revocable trust. If you do want to protect certain types of assets so that you don't control them anymore, and anyone who sues you can't get those assets, we can do it in an irrevocable trust, but you have to tread carefully. That would be like the next level of estate planning. Yeah?
So that would be for like a corporation?
A corporation just by itself does have some asset protection built into the fact that it's a separate entity, right? So if someone sues the corporation, then your personal assets are separated from the corporation assets. That's a little bit like how an irrevocable trust works. If you take your corporation and you put that into an irrevocable trust, you've got another layer of protection. The problem is you also lose control of that corporation. You only get protection if you give up some control. But if you're looking for asset protection, the first layers to look at before we start talking about irrevocable trusts are insurance, our business entities, corporations, LLCs, limited partnerships. There's a lot of different layers of protection that you can put together before you need to actually give everything away to a separate trustee and in an irrevocable trust. I write them all the time. I write them every day. So I'm not saying they're not good, but they're not the foundation for your plan. They're the sophisticated 2.0 level of planning, okay? So I want to just quickly go through what the job is for a successor trustee and to really emphasize that it doesn't necessarily have to be your own children for the successor trustee. It's what a lot of families have in mind, and it might be a good idea for your family. But when you look at this list of things that the trustee has to do, they have to be ready to respond immediately when something happens. They have to step in, right? If your child lives in Japan, maybe that's not the job for them because they're not going to be able to jump in if anything happens to them, right? They also have to get asset information. They have to keep meticulous records. They have to have a ledger with every dollar, every penny that comes through the trust. Is this your adult child? Maybe your adult child is an accountant or a bookkeeper or just a super, super organized person. My daughter's like that, but she's 14. I'm not going to name her as my trustee. They have to also understand the legal document and follow the directions perfectly. If they don't, they're in breach of trust. They've breached the contract and they could get in trouble, okay? This is one of the jobs of a trustee. They have to communicate clearly and often with the beneficiaries. This might not be your child if they're in a fight with their sibling who's also inheriting. Are they not speaking? Then they shouldn't be trustees. They have to work with realtors, tax preparers, attorneys, lenders. They might be talking to the county assessor's office. They might be on the phone with a credit card company. Name someone as your trustee who can handle all of that. This means they should be an adult, and probably an adult who has experience with property, different types of property, right? And then, this is the most important, they're personally liable for any mistake they make. So, let's say they're a day late on paying your property taxes because they've never paid property taxes before. They're your child. They're living in a condo that they rent, right? So they're a day late on the property tax and they have a penalty. They're personally liable for that difference. They have to go out of their pocket to pay the trust back for making that mistake, okay? So maybe you want to think who can handle this important job that carries a lot of liability. And it might not be your spouse, might not be your parents, and it might not be your kids. Think outside of that. There's professional trustees who do this every day for a living. Maybe we think about someone like that to take care of this, because this is something everyone expects their family to do, and it's a lot of work. And it's a lot of specific work where they're in trouble for making a single mistake. That's the way the law works. Like, I wish I could write a trust that gave my trustees a little more leeway to make mistakes, but that's state of California. They're strictly liable for any problems on this. So something to keep in mind, if I could emphasize that. And I know we're a little over the time. We started a little later than I thought, so I'm gonna skip past a few things, but I did wanna just end on this. What do I watch out for? What do we wanna kind of keep an eye out for as we're thinking about estate planning? First, if you get a cold call from someone, or if you get a bulk mailing, an email or a pamphlet in the mailbox that offers estate planning, go into that. It doesn't mean it's bad, but go into that kind of like, how did they get my information and what is it that they're offering? Are they gonna have a one-on-one conversation with me and know everything about my assets and my family? Or are they offering to sell me something that matches everything else, right? That's just like what my neighbor has, who has a very different situation. Also, look for estate planning forms that couldn't be expensive enough that somebody is preparing those professionally and just for you. So if someone's offering you a trust for $50, that's about as much time as it takes to just print it off and give it to you. Like, you don't have an experienced professional reading that and talking to you and making sure it's appropriate for you. If it's the person that you're working with or you're doing other work with and they're putting that in at low cost, that's one thing. But just kind of consider, am I paying enough for this to know that the person who's preparing it is really looking out for my needs, really getting to know what it is I'm looking for? Okay, anyone who's telling you to disinherit people who are important to you, it's never necessary. You can take that to the bank. If someone ever says, okay, just leave this person out, I will take care of them, or leave this person out, or they won't get their benefits, they'll be kicked off their housing or their food stamps or whatever, like, that's never necessary. So if someone's trying to get you to do that, it's a red flag. You can get around those things with careful planning, and you kind of wonder why someone would say that, because I can tell you legally, you don't have to disinherit people who are important to you. Never sign a document you don't understand. People have probably told you that before. I'm telling you now. If you don't know what it says, don't sign it. And then anyone who's selling you something like, I have this one thing no one else has. This is the one thing that I found because the Carnegie family had it, or the Rockefellers had it, and I'm gonna give it to you. This is my secret special program. That's usually totally bogus. Nobody has the secret sauce. This is a type of work that's been done for hundreds of years. There's hundreds of people who do it, right? Work with someone you trust, but if they say they're the only one who can do this one special thing for you, that's usually not true. And then watch out for anyone who's trying to manipulate you psychologically, who wants you to rush into things, who wants you to just trust them that they're doing the right thing. When it comes to estate planning, this work is too important to be manipulated emotionally into something. You want to go into this totally clear-headed, maybe thinking about things that are hard, but thinking about it clearly, thinking about it fully, right? That doesn't necessarily mean that you're working with the most expensive person on the block, but it does mean you're not being rushed into anything, even within your own family. No one should be banging on your door and saying, hey, get this done right away because I'm your child and I love you and I want this to be done. Like, don't do planning when you're being pushed into it. Okay, I think we're over our time. So happy to stick around and talk to anyone. And I've kind of woven out these other sources of litigation throughout. So I think we'll end here and then we'll take questions afterwards.
Yeah. So thank you so much, Mary.
Yeah.
Can we go ahead and take questions right now?
Sure, yeah.
Okay. Does anyone get a question?
Yeah, about the estate inheritance tax.
Sure.
Inheritance tax.
Mhm.
I mean, I know that changes, but like right now, what is the status?
This is the highest exemption from estate tax that there's ever been. It does change from year to year based on it's indexed for inflation. So right now it's $14 million. There's no federal estate tax unless your estate's over $14 million. I aspire to have an estate tax problem. I would love to pay estate tax, right? And I hope all of you have to pay estate tax. Now, that said, when I first started, and it was just 15 years ago, not that long ago, it was less than $1 million. And it's been 3.5 million, 5 million, 7 million, 2.5 million. It's been all over the map. It gets thrown around every time there's a tax change. Every new president, you can look up what they're proposing for the estate tax exemption. It's usually tied to other tax planning, but my point is it changes all the time. Look up on Google what it's been for the last 20 years. You'll be surprised how up and down it's all over the place. Right now it's very, very high as a federal tax.
So does that mean that unless your property is worth over 14 million, then whoever inherits your property,
No estate tax
no estate tax?
from the federal. There's no California estate tax yet. Who knows what'll change, okay? There is in other states. About half the states have some kind of a state estate tax. And then you saw that slide with all the different sources of taxes. That doesn't mean you don't think about taxes. There's still income tax ramifications. Different accounts have different taxes attached. There's still property tax reassessments and other stuff. So, but the estate tax, I'm not talking to most of my families about estate taxes. Most of my families don't have an estate tax problem right now.
So if they were to, if you're, whoever inherits your property, let's say they want to sell it,
Mhm.
and then amongst siblings and they divide it up, they get taxed on whatever the current taxes are for selling the property, minus.
So this is a really common situation, so let me walk you through that, okay? If you died and you have your residence, all right? Then that, and you just own it in your revocable trust because you're really smart and you got a revocable trust, right? So now it goes to your kids in your revocable trust. And they don't want to hang on to the house, they want to sell the house, divide the property between them. What would happen as of today, March 28th, 2026, is that you wouldn't have estate tax as long as your house is worth less than 14 million. God bless you if it is, okay? And you won't have estate tax on that. You also won't have capital gains on the increase on that because after someone dies, all of the gain between what they bought it for and what they sell it for is forgiven. No tax, right? So it will be taxed as though it was purchased at the same price they sell it for. I don't know how to explain it better than that.
Basically,
No
basically
tax,
it
yeah.
starts on, so the day that you pass
Right.
is when the equity starts again. Okay.
Yeah, restarts all the equity, which is great news for kids who are selling, right? Yes,
Yeah.
correct.
So from the date, the value from the date that you pass on to whenever they sell it. That's the capital.
Yeah. And inheritances are income tax free. So they won't pay income tax. So if they all split $100,000 from the sale of the property, they'll get that $100,000 no income tax. They'll just receive it, which is good news for them too.
My thing was on the property tax, on property taxes.
Yes.
If you were part of Proposition 13,
Mm-hmm.
and if you sell to someone out of your family, you lose Proposition 13 totally. Is that correct?
Proposition 13 has been overwritten by Proposition 19. Yeah, you don't have, well, you have Prop 13 on your own property tax now, but the transfer to your kids will not be free of reassessment anymore. Very small exception.
Oh, wow.
Yeah.
So if that it was directly passed on to one of your own in your immediate family is how I always understood.
That is how it used to be. But after 2021, and believe me, that date will be imprinted on my memory because I did a lot of work that day. As of 2021, now if you leave your house to your kids, it's considered a change in ownership and it will be reassessed. The very small exception is if your kids immediately make that their own personal residence, the first $1 million would be exempt from reassessment. So there is still some exemption there, but assume, because most families don't have someone moving in and calling that their house right away, right? Maybe they will, but maybe they won't. Assume there's going to be a change in ownership and a reassessment. And if it is not going to be reassessed and they are moving in, they need to talk to a lawyer right away. Like, get that reassessment in place because it means filing a bunch of forms, and if you're late on the forms, you lose the reassessment.
What's your time frame on that?
The time frame is, so you need to get within 150 days, you have to send one form to the assessor. Within 1 year, you have to get exempt from homeowner. You have to get the homeowner's exemption, which means you need to be moved in and using it as the personal residence. Within 3 years, you have to file the claim for exemption. So it's 3 separate little time frames that need to happen right away. Yeah.
So what's the difference then on the trust with the revocable transfer of death deed?
This is a new one.
Doesn't that save you from the property tax going up when you give it to your kids?
No.
When you do that deed?
Nope, not for property taxes.
Okay.
Yeah.
'Cause we were told that it did.
You were told incorrectly. Yeah, sorry, that's the way it is. Yeah, the deed will, if you do the deed and you follow all the rules with the deed, then you don't need to have put it in a trust because it'll go to whoever you named on that deed, right? Also, the rules are changing all the time on that deed. So now on the deed, there's notification rules. Title companies don't love them, so to transfer title, sometimes the title company will say, I still want you to go to court and get a court order to carry out the deed. It's a new situation, but there is absolutely going to be a property tax reassessment unless one of your children moves in and uses it as the personal residence and gets all those filings in on time.
But you can do that in your living trust.
The living, it's more about the filing. And the living trust won't prevent property tax reassessment either. It's change in ownership now. It's just that's the new rule.
So if the child does stay living in the house and you have a living trust and we have a trustee that files all the proper paperwork,
Right.
they could avoid that.
They could get that first $1 million of value exempt from reassessment. Yeah, that's how you get in. But if that's important to you, make sure on the trust or on the deed, or you tell the child, talk to a lawyer and get that done in time, because this will save you lots and lots of money every year, forever, as long as you live in the house. We want to make sure we keep that, right? It's a valuable resource, but it's trickier to get than it used to be. It used to be just automatically personal residence. If it goes parent to child, guaranteed it won't be reassessed. Even not your personal residence, other properties, not reassessed if it goes parent to child. That is no longer the rule.
And how do you, in the trust, can you protect your property from your daughter-in-laws? Like you want your kids to get it, not
Yep.
your spouses,
Yeah, yeah.
in case they get divorced or
You write the rules in the trust. Yeah. So if you want to make sure it never goes to spouses of children, you can make that really clear. And if you're talking to someone who's done it a variety of ways, you can say how important that is to you. One way to really make sure is so that it never goes outright to the kids. It stays in the trust for the kid, right? And then the kid couldn't even give it to their spouse if they wanted to. Or you can just say, I'm not having spouses inherit, I only want my child to inherit. But once they receive it and they own it, then you can't really control what they do with it, right? But you can absolutely do that planning in your own trust because you're in control while it belongs to you. Yeah. Any other questions? Those were all really good questions. And I'll be sticking around for a little while to answer other questions. this is what I like to talk about every day. It's not what everyone likes to talk about every day. It means a lot to me that you came and you're interested, and I do love working with families like this. So thank you for being here, and I appreciate your time.
Thank you, Mary. Appreciate it.
Thank you.
All right. So thank you, Mary. Great information. I saw a lot of you guys writing a lot of stuff down, so hopefully it was really good information for you. Like you said, she'll be here afterwards a little bit to handle more specific questions. I know there was a couple of you here that already have trusts, and you had some questions about, changes and things like that. So you can talk to her about that afterwards. In the meantime, before we wrap it up, I have some $50 Amazon cards that I'm going to give away.
Wow.
So we'll do that with a little trivia. How's that sound?
Ooh, you didn't know you were going to get quizzed.
You might have to confirm these answers. Yeah. So, okay. So, how often or which situations do you actually review your trust?
Every 1 to 5 years.
Wow.
Marriage, death, birth of a child.
Wow. Holy
Wow. You're hired.
Next question for the final gift card is, there are 2 different powers of attorney.
I know there's financial. All right, I'm gonna go to my
That's okay, we can see here. We're good with that.
financial, I don't know what that's.
Right?
Perfect.
All right, so that's it. Again, questions afterwards. So stick around for a few minutes and enjoy Nelly Loves the Lake and all that stuff.
Yeah.
But thank you guys so much for